Hi guys, so this video is going to cover chapter 10. I'm going to try and keep them short. I'm going to try to cover the entire chapter. However, as I go along, I might have to break it up into two. So, homicide. Homicide by definition is just the death of any person caused by another person. We have three types of homicides: justifiable, excusable, and felonious. Felonious is just a fancy word for criminal homicide. So justified would be, an example of that would be a police officer who was stopping, an armed shooter or a school shooter, something like that. Had the death, that homicide is justified. The police officer was in their means to end that person's life. Excusable. We've kind of talked about these before, but that would be an insanity situation where the homicide is almost excused or explained by the insanity that the individual is going through. But for this chapter, we're really going to be talking more about like that felonious or criminal homicide. When we talk about criminal homicide, that's where we have varying degrees. So we have first degree, we have second degree, there are manslaughter, you have involuntary manslaughter. All of these different levels or degrees of homicide are important to know because that's how we decide what the proper punishment is. Corpus delicti, it sounds fancy, but it really just means the body of the crime, the purpose, the substance. You have to talk about when you talk about taking somebody to court and prosecuting, you have to be able to prove that a crime has been committed. So in homicide cases, it's pretty simple. A person has died, you need to have proof of that. Typically, that comes in the body, right? The individual's body has been found somewhere. We come across we might find a corpse. If it's been a really long time, we might find skeletal remains, but essentially that's part of proving that a crime has occurred here. It is possible to do criminal cases and criminal homicides with circumstantial evidence. However, it's more difficult and it's not super common. You would really need a very strong witness. You need very strong confessions. But typically, and in most cases, how do we know a person has died? Well, because we found their body. So we have to prove A, person has died, B, that another person caused that death, that it's not just a natural death, and that C, the death was caused unlawfully, that is, knowingly, purposely, recklessly, or negligently. The victim must have been living. That means that they couldn't, be dead before the murder happened. You can't kill someone who's dead. And I know that sounds weird, but we'll talk about it in different chapters in different classes. But you may have someone practicing in like necrophilia, where they are having sex with a corpse. Well, that's different than, forcible rape. And it's important to note when the person died and how the person died. More on task here. Common law says that individuals have to be born alive. That up until, recently, you couldn't charge somebody for the death of a fetus. You could have a pregnant woman who was murdered, but there was no charge for that fetus inside of her. So now some statutes in some states have where a fetus was in the womb is a whole nother charge. And some states are still looking at what point was that a viable fetus, but essentially what you need to know is that for the death of a person to be homicide, that person must have been living at the time of the death, which doesn't make sense, but I hope that it does make sense in some form. So one cannot kill a person that was already dead, although it usually is a crime to do violence to a corpse, as I was talking about, jumping ahead of myself, just like I would in our normal classroom setting. The fact that a victim was about to die from another cause does not mean the victim was not alive in a homicide. So this is an example. If a homicide, it is a homicide to shoot a victim and he falls from a 10-story building, though it might be difficult to prove the death occurred before the victim hit the ground. So what they're saying is you've shot him. It's going to be hard to prove that that shot was fatal before that person hit the ground. But when we talk about homicides, you just have to look at the proximity to the case, and is that act tied closely in with the death of the individual. Homicide requires proof that the victim died. That this means that they can show that this person is actually deceased. In some jurisdiction, a person has died only when the heart stops beating and the lungs stop breathing, even if on life support systems. So in other states, if a victim has suffered brain death, that is permanent cessation of all brain functions, death has occurred and a homicide can be charged, though it would normally not happen until life support ended. So just depending upon the state and the statutes and how they define it, that would be how we determine if that victim is dead or not. Homicide requires proof that the defendant caused the death. The cause in fact means that because of the actions of person A, person B died, and that needs to be proven in the court before somebody can be charged with homicide. Proximate or legal cause means that the defendant can be held responsible for the death even though it occurred in a different manner. Here's an example. B died by drowning, not by the gunshot wound. However, because A could foresee B might take risk trying to escape, A's conduct can be proximate cause for B's death. So if A is chasing B and B is trying to get away and runs into a lake, this A can still be responsible because they were the reason that B ran into that lake. They were trying to save their life, run away, swim, whatever. Had it not been for A scaring B, B would have never drowned. Intervening cause. An independent intervening cause can break the chain of causation between the defendant's act and the death. This is a little too far out there for what I really want you to know, so I'm going to go through these next couple slides pretty quickly, but it just means that A stabs B, causing an injury that can be fatal. C comes across the dying, B robs him and shoots him in the head, causing instant death. C's acts are the intervening cause of B's death, breaking A's actions. So, again, I think those are very rare circumstances, but somebody could intervene. If somebody were to see a weak person laying on the ground and then causes that death, it kind of removes that charge from the very first person. Okay, so murder. Both common law and statutory law have defined murder to include more than one combination of actus reus and mens rea. When the acts resulting in the death must be voluntary, the mental state driving the acts can vary. So, intending to kill and planning the result is the degree. Intending to kill and the planning of that killing are first-degree murder. With first-degree murder, you really have to have that premeditation, meaning we've thought about it. This was not in the heat of the moment. This was intended. I wanted to kill. Intending to cause death but without planning is typically second-degree murder. So a real-life example I can give you of that would be somebody robbing. I had an offender at Chillicothe who was really just trying to rob a man, but however, she wasn't ever really intending to kill. However, the person she was with ended up killing. So she was charged with second-degree murder. And when you watch TV or you listen to crimes that are happening, we typically start high, meaning we charge them with first-degree murder, and maybe that individual doesn't quite meet that level of first-degree murder, but we do that so that we can plead them down to second-degree murder. Intending to cause serious bodily injury but not death. This could also fall under second-degree murder, meaning you intended to scare, you intended to hurt, didn't quite mean to kill, but because of your actions somebody died, that's second-degree murder. Even where conduct is not accompanied by intent to kill or cause serious bodily injury, extreme reckless acts showing a wanton disregard for the risk created can be murder if another person dies. It's a big long sentence, but essentially what it means is that when your conduct is so extremely reckless and there's just a complete disregard for the risk that you've created, and you end up killing somebody or murdering somebody, you can also be charged with second-degree murder. You don't have that premeditation, which is the important part of first-degree murder, but you can't go out and do something crazy and then say, oh, it was an accident, I didn't mean to kill somebody. In most states, unplanned or unintended deaths that occur during the commission of a felony can be charged under the felony murder rule. This is an important part. I do want you to hold on to the felony murder rule because you will see that come back up again. But essentially what that means is that you are driving a getaway car from a felony bank robbery. And you hit a car and you hit a passenger, you hit a pedestrian and you kill that pedestrian. Well, you did not premeditate that murder. However, because what you were doing was a felony, and in the commission of the felony that you're committing, you caused the death of another individual, you can be charged with murder under the felony murder rule. Okay. I'm going to stop this video there, and I will make one more video to finish up the rest of this PowerPoint.